Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from the law offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy in English. On Thursday at 5:30 p.m. EST with attorney Chand Parvatneni. And on Friday at 6 p.m. EST with attorney Bhanu Vilindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that Sakshi TV now has Please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. And if you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you get in touch with them, don't forget to mention Sakshi TV. From the beginning, ReadyESQ.com has put a wealth of free information and online tools in the hands of the immigrant community and for the benefit of US employers. The ReadyESQ.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the changes in public law affecting I-485 applicants on the 23rd of December 22. And we will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get onto the topic, you can call us on the numbers displayed on the screen to ask questions related to immigration and also ask tips. Hi, Ms. Reddy. How are you doing?
Hi, Tony. I'm good, thanks. How are you?
Very well, and you look radiating today, Ms. Reddy. I really wanted to start off with that.
Thank you.
So, Ms. Reddy, do we get into the topic right away?
Yes, we should.
Right. So, you want to tell us about the changes in the public charge law affecting I-485 applicants?
Yes. So, public charge laws. What is a public charge law and how does it affect you when you're filing for your green card? This is applicable to everyone that's filing a 485. That means if you're in the country and you're adjusting status, whether it be based on a family-based immigration or it is you're filing through employment-based, you're filing as a dependent, whatever it might be, if you're in the country in order to get a green card, you have to file a 485. And if you're filing a 485, you have to know what the public charge rules are. And this is not a new concept. It's been there for a while. It's just that there have been changes recently, back and forth. It's been like a seesaw, and there was a lot of, under Trump administration, they made it tighter. They expanded what public charges are and who is inadmissible under public charge law, which means pretty much that if you don't meet the requirements under public charge law, you will not get a green card. So just to start off with a brief history, right from the earliest federal legislation, the Immigration Act of 1882, there's always been a public charge law. It basically says that based on the act, the government is able to prevent any person unable to take care of themselves without becoming a public charge from entering into the country or getting a green card or being adjusted to a green card. So there have been subsequent revisions of this 1882 Act, but pretty much the gist of it is that if you are unable to take care of yourself, if you're likely to become a public charge that is dependent on the government for financial aid, then you're not likely to get a green card. You will be inadmissible and your 485 will not be approved. Now this as to what constitutes a public charge has changed over time. And also because it hasn't been well defined in the past, there's been a lot of confusion as to what constitutes public charge. So the first guidance that we got was in 1999, guidance from the field office on deportability and inadmissibility. And the field guidance defined a public charge as an alien who becomes or is likely to become primarily dependent on the federal government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or institutionalizing for long-term care at government expenses. So the original law states that there are two reasons why you could be called a public charge, and therefore, based on that public charge definition, not get a green card. One is if you receive public cash. Cash is a keyword here. Cash assistance in order to maintain your income, meaning you don't have any other income and your entire subsistence is based on getting money from the government. Or if you're institutionalized, meaning hospitalized or put into some kind of government care facility or a care facility under government expense, this would constitute being a public charge and you would be inadmissible. So that was the 1999 guidance, and there was some confusion about that, and they cleared the confusion then, and the confusion was whether the use of Medicaid, and there's a program called CHIP, Children's Health Insurance Program, and other non-cash benefits, if that also applied as a public charge. And the guidance then in 1999 was that immigration officers should not place any weight on receipt of non-cash benefits other than the institutionalization for a long term. And even the institutionalization, if it is only intermittent and or it's for a short term, that doesn't count as a public charge. But things changed after that. In 2019, under the Trump administration, Trump issued new regulations that broadened the scope of this program and broadened the scope of what would be considered by the federal government as a public charge. And they included previously excluded benefits, and they included health benefits that you get free of charge, nutritional benefits, meaning like food stamps and other nutritional benefits, and housing programs as well. So if you're taking the benefit of a low-income house or getting free housing from the city, then that would be constituted as a public charge under the 2019 rules. So they also included non-emergency Medicaid, which was not included before. If you were not pregnant and you're an adult and you're getting a non-emergency Medicaid, then that would be counted as a public charge. The SNAP, which is Supplemental Nutritional Assistance Program, housing programs, all these would be considered public charges under the Trump administration. And, because of this broadened definition of what constitutes a public charge, many people, even though they would not be under public charge, stopped taking a lot of the benefits because there was a lot of confusion as to what constitutes public charge and what doesn't under the 2019 rule. So basically this had a chilling effect on all public benefits. So a lot of people, even for their children, even though they were not taking it directly, even for their children, they didn't take public benefits. Pregnant people didn't take housing, etc., etc. So that was something that was not that could not be predicted, but that's what happened. So as a result of which, and as a result of a couple of court cases being filed in different states, the 2019 public charge rule was withdrawn by the subsequent Biden administration. And in place of that, they created their own rule, which was the 2022 final rule on public charges. Now, this Biden rule pretty much mirrored what was, previously the rule, and it largely codified the 1999 field guidance that we talked about. So, and the purpose also of making clear what is a public charge, what is not a public charge, that was one of the purposes for writing down this rule in detail, because they wanted to avoid all the confusion as to what constitutes a public charge and what doesn't. So basically the 2022 public charge rule, which is now going to be implemented starting from December 23rd, 2022, end of this year, And the 485 forms, please make sure you use the new 485 forms if you're filing a case after December 23rd, because the new 485 forms have a lot of questions about public charge. So, you know, it's better defined. So they're asking questions which have to be answered. If you use the old form, that your case will be returned. So the new 2020 public charge rule pretty much returned to the 1999 public charge definition, and basically said that someone who is likely to become primarily dependent on federal government, as demonstrated by the use of a cash assistance program for income maintenance or government-funded institutionalization, long-term care, such as mental care or health or nursing home care. They will be, it's completely funded by the government, then they would be defined as a public charge, and they will not really get the benefit of a 485. Now, they've also clarified that the federal government will only consider cash assistance programs, as I said earlier, except for institutionalization, other programs that will all be cash assistance, so not other assistance that you get from the federal government. So this includes supplement social income, it's called SSI. It includes temporary assistance for needy families. It includes state, local, and tribal cash assistance to pay for basic needs such as rent, food, utilities, etc. And also, as I said, long-term institutionalization also comes under this public charge program. So Medicaid funded services, Medicaid usually is not considered to be under public assistance, but if you're using Medicaid for long-term institutionalization, then it would be considered to be to come under public assistance. So I think, hopefully it's a little complicated, but really only two things that you have to remember: public benefit, which is cash-based and which is pretty much being used as your main income, and long-term institutionalization. These two will come under public charge. Now, there's a difference in the 2022 proposed the rule. Right now, it has been finalized, and the earlier Trump rule. Under the 2019 rule, housing assistance, SNAP food assistance, Medicaid, including cash benefits, TANF, and SSI, all these were included under public assistance. Under the new rule, Medicaid, housing assistance, all this is not included under food assistance, all this is not included under public assistance, under the public charge rule. And another important difference is, even if they find that you have taken one of these benefits in the past, so the way they decide whether you get a 485 or not is, they want to see whether you're likely to become a public charge or not. And the way they see if you're likely to become a public charge or not is whether you've actually used this in the past. If you've used those programs in the past which you're not supposed to use, then they might determine that you are likely to become a public charge in the future also. But that's not the only criteria. Past use is not the only criteria. They also look at other factors such as your age, what your family status is, your health, how educated you are you able to earn a living, what income you have, what resources you have. Also, most importantly, if you have a family member that's qualifies and is able to fill out an I-864 affidavit of support for you. If someone is able to fill out an affidavit of support and has sufficient income to support you, then that's another consideration, a very important consideration that they would come into play, right? So this is, I think, in a nutshell, what the old rule said and what the new rule said, and presently what we can look forward to with reference to the new rule. They've also said that if you are a family member and you're applying for a benefit for a child, and it's not for yourself, even if it comes under one of the public charge assistance programs, you will not be disqualified from getting a 485 because you're not doing it for yourself. Also, say you've applied for something in the future, but you are not using it right now. That also is not a criteria for you to be disqualified under the public charge rule. So they've given some more, they've made some deviations actually from the 1990 rule, and these are the deviations. That family members applying for other family members, not for themselves, will not be under the public charge rule. So that's an important deviation they made, even from the original 1999 rule.
Right. So, in a nutshell, I think you've covered quite a lot, Ms. Reddy. But also, we do have some questions regarding, this. I mean, who starting off with the questions, Ms. Reddy, who is exempted from the public charge rule according to the latest one?
So there are a lot of categories that are exempted, meaning that even if they take the benefits that they're not supposed to, they still will not be disqualified or inadmissible under the public charge rule. They are refugees. If they were admitted at the time of admission, if they came in as refugees into the country, if they got asylum approved, if they are American immigrants, right? They're very specific and not many people qualify, but Afghan and Iraqi interpreters, so people who are from Afghanistan and Iraq who have helped during the American wars as interpreters, etc., they will not be disqualified. Cuban and Haitian entrants applying for adjustment of status, people from Cuba and Haiti. Also, individuals applying for adjustment of status under the Cuban Adjustment Act. Also, Nicaraguans and other Central Americans applying for adjustment of status under the Nicaraguan Central American Relief Act. So there are a whole bunch of people that don't qualify. Individuals in T non-immigrant status. I'm not going to mention all, but some of them. People under C2. So people are working for the government under C2 on a G visa. People working for the UN. People non-immigrants classified as NATO representatives, Syrian nationals, Liberian refugees, people who are filed under the Violence Against Women's Act, under VAWA. They're also not, this law doesn't apply to them as well. So these are some of the people that, the list is exhaustive. There are about 27 different categories, but just to name a few, these are some of the people who are not affected by the public charge rule.
Right. And Ms. Reddy, what benefits are not considered for public charge purposes?
So I mentioned some of them earlier, but it might be useful to just list them as well. SNAP, also known as food stamps. So if you're taking food stamps, you're not getting money, you're getting stamps with which you can go to a grocery store and get food. So that's food stamps program. So you will not, that will not be considered a public charge. Children's health insurance program, CHIP, so free health insurance paid by the government for children. Medicaid, this is again free, it's like a free health insurance. You get free health benefits. Of course, this Medicaid does not include the long-term institutional services. So if you're in a nursing home, mental health institution for a long period of time, then even though it's under Medicaid, you will still be considered a public charge. Special Supplemental Nutritional Program for Women, Infants and Children, WIC. Housing benefits, such as federal rental assistance, meaning that the federal government will pay your rent, or you'll be put up in free housing. Benefits related to immunization or testing for communicable diseases. For example, if you get a COVID vaccine, a free COVID vaccine, COVID vaccination is free. That will not be considered to be a public charge. Disasters or pandemic assistance. A lot of people in the US got assistance for COVID-19, got money. So there was a lot of assistance given. Also, similarly, if you get assistance for a hurricane or some other natural disaster or some other pandemic, you will not be considered to be have been under the public charge. For example, under the 9/11 disaster, when 9/11 happened, a lot of people got public assistance under FEMA, so they won't be considered. That won't be considered to be a public charge. Free or subsidized school lunches. Children, if they go to public school, can eat free lunch and free breakfast. That will not be considered to be a public charge either. Use of home and community-based services, other non-cash supplemental or special purpose benefit programs. So as long as it's non-cash, I've mentioned a few, but these programs are all are not considered to be disqualifications under the public charge rule.
Right. Right. And Ms. Reddy, what public benefits, implicate the public charge rule?
So the following benefits may be considered to be a public charge. We talked about what benefits are not public charge, but if you take these benefits, then definitely you will be considered to be a public charge and you will not get a green card. So receipt of federal, state, local, or tribal cash assistance for income maintenance. So you don't have any money to sustain yourself. The government is giving you money. That includes supplemental security income, SSI, temporary assistance for needy families, TANF. This is cash. So as I said, any cash benefit, especially these two mentioned benefits, it will be problematic. Also, as I said, long-term institutionalization. So these two things come under public benefits, under public charge.
Right. And while we're on that subject, Ms. Reddy, does receiving the state-based subsidized health insurance implicate public charge concern?
No. So just getting, provided that the state-based health insurance is not funding long-term institutionalization. Again, we keep talking about that. So as long as you're not using it for some long-term institutionalization, getting state subsidized health insurance is not included under public charge.
Right. Right. And Ms. Reddy, if a state uses federal funds to provide health insurance, would that create a public charge?
Again, no, because the DHS doesn't consider health insurance when making public charge determinations. Again, unless it funds long-term institutionalization, generally getting health benefits is not considered to be a public charge.
Right. Right. And does using Medicare Part D implicate public charge consideration, Ms. Reddy?
Yeah, under the Trump law, it did. You couldn't use Medicare, but under this present law, non-citizens may always use Medicare without any implications to the public charge concerns.
Right. Right. And Ms. Reddy, if a natural disaster, impacts a person, and can that person accept cash assistance from federal, state, or local governments without implicating public charge concerns?
Again, yes, as I said, disaster relief does not implicate public charge considerations. The Department of Homeland Security allows non-citizens to accept, all those benefits.
Right. And does the public charge rule, does it apply retroactively, Ms. Reddy?
So yeah, it could, which is unusual for laws to apply it retroactively, but this one could, because the USCIS, the USCIS will consider past receipt of public benefits, right, in determining whether a person is likely to become a public charge in the future. So they look at past actions. So yes, it could be considered to be retroactive.
Right. Right. And Ms. Reddy, can a person accept donations from, charitable organizations such as the Salvation Army, religious groups, or other private groups without implicating a public charge concern?
Yeah, because public charges determinations are made only based on public benefits. So these donations are all from private groups. So it really it's not considered to be a public charge.
Right. And can a person accept food from their local or state-funded food bank without implicating a public charge? Can that happen?
Yes, because food stamps, as I was mentioning, the food stamps program, that's a non-cash assistance, and it's not considered to be a public charge.
Right. Right. And can somebody accept housing assistance, Ms. Reddy?
Yes, again, this is non-cash assistance and is not considered to be a public charge.
Right. Right. So, do the visits to emergency room implicate a public charge concern?
Right. So if you go to the emergency room and you don't pay because you don't have health insurance or whatever it is, healthcare is not included again, as I said previously, in the public charge determination unless it's funding some long-term institutionalization at the government's expense.
Right. Right. So, there's another question to Ms. Reddy. Can my child receive school lunch or school-based nursing care without implicating a public charge concern?
Again, yes. Again, yes, because this is non-cash assistance and it's not considered to be a public charge determination.
Right. And what about primary caregivers, Ms. Reddy? Are they exempted from the private charge, rule?
So it doesn't matter whether you're a primary caregiver. That's not really a factor in considering whether you're public charge inadmissible, because there are other factors, right, as to whether you took that certain public benefits which were not allowed. That's the factor, not whether you're a primary caregiver or not.
Right. Right. And there's also another one, Ms. Reddy. The COVID has impacted me and may I access public health benefits without implicating public charge concern. Public benefits, sorry. Yeah.
Right. So yeah, pandemic assistance again is not considered to be a public charge because that's a health benefit and it's not a cash benefit.
And about pregnant women, Ms. Reddy, can they use Medicaid for non-pregnancy related medical visits?
So this is a moot point, and the reason they're asking this question is because under the Trump administration, nobody could use Medicaid except for pregnant women. But under the present administration, anyone can use Medicaid, and they will not be considered to be a public charge. So yes, even if you're not pregnant, or if you're pregnant and you use Medicaid after, not related to pregnancy-related visits, you will not be considered a public charge.
Right, right. And what about? I mean, this is about pregnant women, but what about women who are nursing, Ms. Reddy? I mean, what if they're having trouble feeding their newborn child, and can they apply for the special supplemental nutrition program for women, infants, and children, WIC?
Yes, as I said, WIC benefits are not considered in the public charge determination because again, they're not cash benefits. These are programs which give, newly born infants food, proper nutrition. So it's not a public charge.
Right. And what about the child being able to use Medicaid after the 60-day window for pregnant women closes, Ms. Reddy? Is that possible?
Again, that's a 2019 concern.
Right.
It's not a concern anymore because you can use Medicaid freely without implications in this, as long as it's not for long-term institutionalization. Under this law, you can freely use Medicaid.
And what about women who've had a miscarriage, Ms. Reddy? Under the new law, are they still entitled to use Medicaid?
Right. Yes. Same thing. Medicaid can be used as long as they're not, again, institutionalized for a long period of time.
Right. And we have a last question, Ms. Reddy. What if the child and parent were in a car accident and suffered an injury? Can they seek an emergency medical care without implicating the public charge?
Right. If they go to the emergency room, again, same as the previous question, they can seek health benefits and emergency medical care because that is not under the new public charge program.
Right. I think we've covered pretty much everything about this topic, Ms. Reddy. That is the first. I mean, we've always really had so much information to discuss. And I think you've always given us so much information. We never could, fit in the wealth of information into one episode. So thank you, Ms. Reddy. It's always a privilege hosting you. And thank you for the humongous amounts of information that we're subjected to. Thanks to you.
Thanks, Tony. That's, I try to do my homework before every show so I can give some useful tips, to my viewers.
Of course, Ms. Reddy, that shows. Thank you so much. We're so glad to have hosted you. You're watching Sakshi Live. This is Thorni. Thank you.